attorney that spends most of my time doing estate planning work, both the planning side of it as well as after someone passes, the administration of an estate, whether or not it involves a trust or probate, a couple topics that I will touch on this evening. And then do a fair amount of business succession planning too, a lot of closely held businesses. So if you have a family business and how you succeed that to the next generation, and it necessarily involves some of this planning too. So that is what I do. And if you picked up a handout, the phone number and address of our office is on the very back page, and please do grab a pen if you didn't, and it has the phone number. So if you have a question after tonight, feel free to give me a call and I'll be happy to address any question you have. Okay, as a refresher, if you remember this from the past or you've had conversations about estate planning before, or if this is all brand new to you, I will just remind you that a basic estate plan should include at least a handful of documents that would be common to everyone, regardless of your situation. Because estate planning, I don't think estate planning is a one-size-fits-all. I mean, you will find things online. You can perhaps do that online. I would just caution you, because honestly, sometimes if you do that, it may seem simple, but when those have to be implemented, it may be more of a problem than if you just, whether someone like me or your own personal attorney, I just suggest that maybe you seek individual advice. But an estate plan should include a couple of documents that are very important for you while you are living, and those are power of attorney documents for financial purposes as well as health care. Okay, and those allow you to name an agent for someone to speak for you for financial or health purposes if you're not able to. I'm not going to go into a lot of detail with that right now. Most people think of estate plans, they think of a will, or what do I need after I pass away? And that is when the idea of a will comes up, but that's also when you can think about a trust. And trusts, there's actually a number of type of trusts. But before we go into that, I will remind you what a will does, because I think that's important so that you can understand how a trust may complement that or may be different from it. A will is a document that directs how you want your probate assets distributed at your passing. Of course, I have to bring up yet another word that you may not be familiar with. A probate asset is an asset that, if we look at the face of it, we don't know what we're supposed to do with it when you pass. So for example, if we look at your car title, if I look at my car title, it may just say Julie. Nobody knows what's supposed to happen with it when I pass. That is where your will would control. And that is where we then have to go to the court, get a personal representative, or the older terms executor, appointed to then have the authority to transfer those probate assets. Okay, so the will, it controls that. Non-probate assets, if we look at the face of a non-probate asset, it tells us what we're supposed to do with it when you pass. So the will does not control that. What are non-probate assets? Ones that most people think of is life insurance. There's a designated beneficiary. We know who it goes to. Retirement accounts. You probably have a designated beneficiary. Jointly owned assets. If oftentimes spouses will own their homes as joint tenants with rights of survivorship. That means at the first passing, automatically the survivor becomes the owner. Okay? Another type of a non-probate asset is any asset that is already titled in the name of a trust when you pass away. So, kind of leading into, should I have a trust? What is a trust and why would it be useful? There are a number of types of trusts. Okay? We're going to focus on 2 or 3 of them this evening. The main one that we think of is a revocable trust. Some people say revocable. It's the same thing, okay? And I brought, actually, I didn't tell Barb I was going to do this. I have a little, I don't know what you want to call it, a tool here to help show us how a trust is used. If I have a revocable trust, think of it as a bucket, okay? I'm holding on to the bucket. A trust, what I'm trying to also show you is it does not have to be as complicated as you think it might be. So if as part of your estate plan, you have a revocable trust, that means you have a tool or part of your plan that can be changed. Just like you can change your will, you can change a revocable trust. If it's for one person, the person who sets up the trust is referred to as a settlor. Some people use the term grantor or trustor. I'm going to use the word settlor. So if this is my trust, I'm the settlor, and I'm holding on to the handle of this bucket during my lifetime. That means if there's any tax activity that goes on, like I put, and I'll get into more detail in a moment, but I've put my house in this trust. I've put a bank account in this trust. If there's any tax activity that goes on in this trust during my lifetime, my hand's holding on to it. So it flows through to me, and it's associated with my Social Security number, meaning a revocable trust during the settlor's lifetime is tax neutral. There's no upside for tax purposes, there's no downside for tax purposes. So I want to put an account in, or I put my house in my bucket, it's there. I want to sell that house. I can take it out and sell it, just like if it's my own. And again, I said it's tax neutral. So you're not going to have any difference if you're transacting those assets in here. Oftentimes, what I will do is create trusts, a joint trust. So if there was another person up here, that person, so if I'd made Mike stand up here as he was testing earlier, he could grab on, or Barb will grab on. And we're both holding this, okay? And everything I just told you would be the exact same. We can put our common assets in here or our separate assets. And I'll let Barb, don't go quite yet, but we're gonna let Barb step off here because this will also give an example of how the trust can be used. So let's say that Barb is no longer with us, okay? Then Barb lets go of the trust. But if it's a joint trust, thank you, with the two of us, this trust can still remain in place, okay? And if it were a situation where it was a couple, a married couple, typically the taxpayer's Social Security number is the one that would be used initially. But if that's the person that happens to pass first, then it's the surviving spouses. But again, it's an organizational tool. And so why would you want to do that? As I said early on, as I kind of transitioned into the trust, anything that's already in this trust when I pass away is non-probate. Trusts don't die, okay? Who benefits from a trust can change. So figuratively, if we have a trust document, figuratively, page 1 might be while husband and wife are alive, all the trust assets benefit the husband and wife. Figuratively, page 2, one of the spouses passes. The trust assets benefit the surviving spouse. Page 3, after both of the spouses have passed, then it's who are those remainder beneficiaries. And very often, that figurative page 3, after both spouses, or if it's a single person that has the trust, after that main person, after the settlor has passed, that page that says what happens after that person is gone, oftentimes looks very much like what you expect a will to look like, okay? So if you have a revocable trust, your will, you still need a will because Just very simply, if you have any probate assets at your passing, we have to use the will to make sure the stuff gets into the trust, okay? But the trust isn't going to tell us how those assets are shared. It's all in the trust. So sometimes people want to use trusts to avoid probate so that they don't have to involve the court. And a trust is a private document. It doesn't get filed with the court. Sometimes we register a trust with the court, but you're not actually giving a copy of the trust. If your estate has to go through probate, so there has to be a personal representative appointed, it's referred to lodging. We have to lodge the will. We have to actually give the will to the court. And then in today's technology, they upload it into the system, and you may have to jump through a hoop or two, but it is a public document, so anyone can have access to it. And sometimes, believe it or not, I might have situations, families, estates that I'm dealing with that, believe it or not all family members get along, especially after someone passes. And so that gets very interesting, because if it's a will, any heir, whether or not they're in the will or not, has a right to see that will. If it's a trust, not necessarily. We can keep it very, very narrow in that only the people who are mentioned, the people or the organizations that are mentioned in the trust, have a right to see that. Okay, so there are some privacy issues there. A revocable trust is just that. It can be changed during the life of the settlors. But so back to this, I'm the surviving settlor. Once I pass, I can't hold on to it. So it's sitting here by itself, and it's no longer associated with anyone's social security number. So at that point, it has to get its own tax ID number. And any tax activity that goes on in it would be separate and apart from an individual. But I mean, this could take a long, couple hours to discuss this issue as well. But there is a way that once it becomes irrevocable, and we get to that last section of the trust as to how the assets are distributed, or if they stay in trust, we're able to get those assets perhaps to separate trust shares or outright to certain people. So ideally, we're getting the tax activity out of the trust to other people, and that can be done in a beneficial way as well. Let me see. So so one thing to remember, though, is even though this could be a private document, that there might be reasons that a certain taxing agency may still need to see some of the information from the trust, especially, if we're talking about an estate that's going to be subject to federal estate tax, which right now, I mean, that's a pretty big number. The threshold for federal estate tax, an individual has to have an estate in excess of about $13.8 million. Next year, that number is supposed to drop down to about $5.5 million. And actually, that's a good point to bring up right now, because not that a trust, we can't hide the wealth. Legally, you cannot hide the wealth in the trust and say, oh, we'll avoid that kind of tax. But if there is a way, a legal way, to be able to minimize the tax, the federal estate tax, come up with mechanisms to do that, a trust is the way that we do that. So a trust, you could start with a trust today. You might say, well, this is kind of a good idea. I might want to do that, but I don't know, I don't have that much wealth. That is kind of a myth that that there's a certain amount of money you have to have a trust. That's not true at all. Some people, some clients I have, very modest estates, but they want some privacy, and they just want their family to avoid probate. They might have a house, a couple bank accounts, a car, that might be it. But we have a trust, they put the house in the trust at first, maybe they don't put anything else in there. In that case, we often refer to it as a standby trust. So it's there, it's ready to be used. Yes?
How do you put the assets in the trust?
That's referred to as funding the trust. If it is real property, land, a house, we just do a deed that would go from you. You're the grantor of the deed, and the trust is the grantee. So we just do a very simple transfer of that. And like I said, if this is your trust, you're holding on to it, it's your tax ID, it's exempt from transfer tax. So aside from the filing fee for, just recording the deed, there is absolutely no additional cost. And anticipating another question, if I have a loan on my house, is the bank going to make me refinance? No, because I don't work for a bank, but I've never heard that they make you do that, because again, it's your social security number. It's you. It's just quite literally, it's an extension of you, okay? If they're bank accounts, it's just titled in the name of the trust. So if you do a checking account and you want your checking account in the trust, if you think of your checks, if any of us actually use paper checks anymore, on that top left-hand part where it might have Julie and my address, instead it's going to say the Julie Trust, Julie Trustee, and then my address. And if you do that, you still just write your checks the same way, but you need to write the word trustee after it. And that actually brings up another point, is a trust has, what would you call it, 3 positions, okay? Initially, if you individually or as a couple are the ones setting up the trust, again, if you're the ones creating it, you're the settlor, okay? So one of your hats says settlor. The settlor is the only one that can make changes to it, can create it, can put assets into it, okay? But you initially are also, 9 times out of 10, going to be the trustee. The trustee is the one who carries out the provisions on the trust. So if it says, to distribute funds to the settlors, it's the trustee is the one that does that. To your question, if you put your house into the trust and then you later want to sell it, who's the one that tips the bucket to get the house out? The trustee. You may be the settlor and the trustee, but when you're putting that out, the deed at that point is going to be signed by you as the trustee of the trust, even though you're the settlor. The settlor created the trust, but it's the trustee that transacts. I think of it as the trustee is like the manager of the trust. So you're following that rule book. The other position in a trust is the beneficiary. Initially, you're probably also the beneficiary, at least of the revocable trust, which is the main estate planning type of trust. A beneficiary really doesn't have the right to do anything except stand there with their hands out and be able to receive the assets, okay? What we just talked about is a revocable trust, and that, yeah, go right ahead.
Where exactly, like I had a law firm in Denver, put my house into a trust when I bought the house. Where is that? Is that with the law firm as the trustee, or can I have another law firm closer to home do the transacting? How does that work?
Yes, it could be that the law firm is the trustee. If it's your trust and you seem very capable, I would highly doubt that anyone other than you is probably the initial trustee. They probably, just like I would draft a trust for someone, make sure it all gets signed, we do the initial deeds, get them transferred to the clerk, or submit the deed to the clerk and recorder so it's reported or recorded. Some law firms hold on to the original trusts. Others, like our firm, we don't hold the original documents. We make sure we have copies. But ideally, if you have the original, or you should at least have a copy. That is your document. You can, in the future, you can have anyone assist you with that. If it is a revocable trust, there shouldn't be any reason, I won't use a double negative here, there is no reason that you could not make a change. So if you don't like who's trustee, you should have the right, again, as the settlor, to make a change to that trust. So I would, if you have a question about it, I would call that law firm and just ask them those questions. Yes, yes.
So a weird question. Let's say I set up a trust for me,
Mm-hmm.
and I set up a trust for my wife.
Mm-hmm.
We want to put the house in trust.
Yes,
Can we put the house in both trusts?
yes, you can. And it used to be very, very common that even if the spouse's intent for how the assets would be shared is identical or it mirrors, it used to be the most common practice was for each spouse to have a separate revocable trust, because the tax law, we wanted to equalize the value of the estates for tax purposes. Now, again, this whole nother discussion, but we don't necessarily have to do that, and that's why we often use a joint trust. But if you were to do that, if you had two trusts and you wanted the house half interest in each, you would do that. And I see that frequently. But what you have done then is, like right now, if you own your home jointly as joint tenants, only humans can be joint tenants because it deals with survivorship. And actually, as I said, trusts don't die. So you would be, the two trusts would be owners as tenants in common, meaning that each one owns that half interest. So yes, you absolutely can do that.
Yeah, but you accomplish basically the same thing if you make each trust the benefit of the other, the
Yeah.
beneficiary of the other.
Mm-hmm. And there are times to do that, and very, very much so. There can be some tax reasons potentially to do that, and that's very, very common to do in blended family situations, is that each spouse has his and her own trust, because whatever is in your own trust, again, as the settlor, you're the one that controls the rules. And you may want, for example, the surviving spouse to have the benefit of the assets during his or her life, but you might want to make sure that the assets you've brought into the marriage will eventually benefit your kids. And so there's a way to do that. And typically, if you're doing that, you would use two trusts. Yeah, that's very common. Yeah, yes?
So another question down the real estate rabbit hole. My parents created a trust, a revocable trust, and they funded the trust with their property, real estate property. When they funded it, was the deed supposed to be filed as a new owner of that real estate with the county in which they owned it?
Mm-hmm. Yeah, yeah. It's kind of odd. It's and I'm licensed in Colorado and Nebraska, and even between those two states, I see a difference. If you have in Colorado, it's actually the trust that's the owner. In Nebraska, it's the trustee. Now, granted, like a trust agreement, a piece of paper, how it's the owner, I don't know, but because you still need a trustee to sign. But yes, if they funded the trust, if they completed a deed that granted it to their trust, when you look at the county records, the clerk and recorder, it should reflect the trust as the owner. If it has their name, it's because it's referencing the trustee. But yes, it should be. And if you don't see that, I would go back to the attorney that did that and ask them to please check their file drawer and see if they have a signed deed that they never recorded. Because that, believe it or not, that happens. And then that opens up a whole nother can of worms, that when was that transfer effective? Was it the date they signed it, or was it the date they recorded it? So I thought what you were going to ask me, and I won't get into a whole lot of tax stuff here, but sometimes people will ask about the basis of property, especially if it's, say, a second home. What I'm getting at is, with your primary residence, if you sell your primary residence and buy another house, especially in the environment we live in now, chances are you're going to make a profit on your house. And as long as there's certain numbers, but as long as you buy another house, you're not going to have any capital gains consequence. But if it's, say, a rental property, so it's a capital asset, I guess two things here. You're not going to change your potential tax consequence by putting it into a trust or not. So if you had an asset, if you had a rental house that you bought for $100,000, you sell it for $400,000, and you're gonna have capital gains on that $300,000 gain. Same thing if you put it in a trust, okay? So that's the same. If you want to be able to use the homestead exemption and it's your revocable trust, you still can. It's the same because it's as though you own it. The other part, the positive with the capital gains issue is, perhaps you know this, maybe you don't, that if anything someone inherits because you have passed away, that's an appreciated asset, they're going to get a step up in basis. Meaning, back to my silly example, if you had an asset that you bought at $100,000, today it's worth $300,000. If you sold it, you would have capital gains. If instead, and if you gave it, say, to your child today, they're gonna take it at that $100,000. If you put it into your trust and you gave it out of that trust to somebody today or you sold it today, same thing. But whether you own that in your own name or it's in your revocable trust that becomes irrevocable at your death, you will get the step up in basis. Meaning, under current law, appreciated assets at your date of death or at the date that trust becomes irrevocable gets the same step up in basis. So, using my numbers, if at your date of death it's worth $300,000, whomever you've left it to will take it at that value. If they keep it forever, it makes no difference. But if they then want to sell it, they're not going to have capital gains. And that's back to my point that trust is tax neutral. Now, I'm going to touch on one thing I'm going to skip over what's in my outline. I'm going to touch on, just for a few minutes, the irrevocable trust. And again, depending how you pronounce it, irrevocable. Aside from irrevocable life insurance trusts, which if you've ever talked with an insurance person selling you life insurance and they refer to an ILIT, this is what they're talking about. Irrevocable life insurance trust, ILIT. That is about the only type of irrevocable trust that I am comfortable doing. That if you were to ask me to do an irrevocable trust for any other reason, it's the one time you would see me almost argue with you, and we would talk about it probably 5 times before we did that. It's the irrevocable trust for life insurance. It's a very good tool. If people buy life insurance for purposes of being able to fund, say, some tax, some death tax, so to speak, when you pass, that's very useful. But what we don't want to do is have the value of that insurance increase the value of your estate if you bought this life insurance to pay for that. So there's a way that we can do a separate trust, and it's irrevocable. But if you have interest in that, we can talk about that, but that's all I'll touch on right now. People will often talk about an irrevocable trust for Medicaid planning, okay? I thought somebody might have asked this when we were talking about the revocable trust, and that question I was anticipating was, so can I use that trust and then I can qualify for Medicaid so the nursing home doesn't take my money? No, the revocable trust, remember, you're holding on to it, it's like it's your money, okay? An irrevocable trust, we'll switch sides here. Irrevocable trust is sitting there. I can't hold on to it. It might have my assets in it, and I've written the trust agreement, but once it's created, it's hands off. and I get no benefit from it. People will use those with the idea that if they've put the assets in there, then it's not theirs, and if they need to qualify for Medicaid to pay for nursing home care and such, that they can do that. Well, this is why I say I'm not a fan of doing this, because those rules can change at any time. If I'm going to do that, it needs to sit in there for at least 5 years before it's not mine. And it's really no different than if I gave it to somebody. So if I just gave things early to my kids, and anticipating someone saying, well, can't you get the income from it? Because I knew somebody 10 years ago that they did that and they kept the income. My initial point, those rules change all the time. That's one of the rules that changed. That I do a fair amount of work for farmers and ranchers, and they will want to put, and historically have put land into these irrevocable trusts, but they continued to get the income off it, and that's all they needed to live, but they protected their land. So they made sure it went to the kids. They didn't have to use it to pay for nursing care. Medicaid figured that out and said, no. If you have any incidence of ownership, if you get any benefit from anything in there, we're going to deem it that you own all of it. So it's scary. There's still people out there that will draft a trust saying, yeah, you get the income. But be very, very careful with that. So that is usually where you will hear of the irrevocable trust, but you've given up all right to it. It's effectively like you've given it to somebody else, but maybe you have it sitting in this trust until some magic day that you let it go out to everyone else. There are times, I'm going to talk about special needs trust, which there are times a special needs trust is irrevocable. And that is what we would refer to as a first party trust. And then there are special needs trusts that are over here that are revocable. That is a third party's special needs trust. If any of you in here wanted to create a trust for the benefit of perhaps a child that's a special needs child, or maybe there's another member of your family that's special needs. And what I mean by that is that they're in a position, perhaps a disability, some way or another, they're not able to manage their own assets, and they are able to qualify for public benefit that's based on financial need, okay? And if you're familiar with that at all, you know that they're limited as to what value they can have in their name, otherwise they're disqualified. So if the reason that they're a special needs person is perhaps because of an accident that they collected a large settlement on, okay, that's over here. Because if that person was injured and in a settlement they collected the money, that's a first party trust. And there's a whole way it gets set up, and we're not going to focus on that today. But that would be irrevocable. If you're over here and you're mom and dad and you're wanting to set up a special needs trust, and you could set it up as a standalone trust, meaning it's a trust right now, that would be for their benefit. You set it up, you're the settlors, you can be the trustees, but the beneficiary is going to be that special kiddo that needs the funds but can't be in his or her name. And there's a special provision in there that essentially allows the trustee to distribute for really any reason at all except for the reason that they're receiving benefit. So this is overgeneralizing, but if they get benefit for housing, then you cannot distribute for housing purposes, okay? And they can be written in such a way that if that condition that got them that benefit, if that goes away so they're no longer receiving that benefit, It's a very discretionary trust. So the trustee could then go ahead and distribute for that purpose. So that trust you could create now. You don't plan to be going anywhere any too soon, so you're still going to be around. But why would you do that? I had some clients just in the last month that did that because we'd had a conversation about grandpa and grandma they were preparing their will, plus they were starting to do some gifting to their grandkids. And my clients had recently talked to me and they called and they said, I just told my parents they couldn't give our daughter any money and they're really upset about that. And so we talked about it, and what they are doing is they created a special needs trust. They're the settlors, they're the trustees, the daughter is the beneficiary, but they can accept funds. A check can be written to the trustee of the special needs trust, like during grandpa and grandma's lifetime, or grandpa, grandma, aunt and uncle can put in their will that for this particular granddaughter, it goes to the trustee of this trust, period. And they don't have to worry that their parents' attorney knows how to draft one of these trusts, or how many separate trusts are we going to have out there. It can just go into this one. If, on the other hand, the only reason that you would want a special needs trust created is after you pass away, and you want to make sure that whatever you would leave for your child is in a special needs trust, you can do that within, if you're using a trust of your own, when we get to that page that has the ultimate beneficiaries, or if you use a simple will. A will can have a trust built into it. That's referred to as a testamentary trust. If you think about it, a will, we all just say will, but if you think of the really long name, it's last will and testament. So if you create a trust in the will, that in simple English is, if these conditions exist at my death, basically if my child hasn't reached this age, then I want a trust created. That's only created at your death, okay? That's part of your will, or, like I said, figuratively on page 3 of your trust, then a trust could be created. Everything I just told you about the special needs trust, you could put that in that will or in that trust for just after you're gone. But if you did that, there couldn't be any lifetime gifting. While people are alive, how I said grandma and grandpa could put it in. You couldn't use that. But you definitely can do that in your estate planning documents for when you're gone. And it doesn't need to be just a special needs trust. If you want to provide for, in Colorado, a person has to be 21. Colorado is a couple ages of majority. To be their own person and not need a guardian, that parents aren't the guardian, it's 18, okay? But in order to receive assets of any significance, and I should know that number, it's like, I don't know, somewhere just under $20,000, that if anything greater than that, they need to be 21. So that means if you're leaving anyone any significant gift at your passing and they're under the age of 21, because if you're a resident of Colorado, that's what controls. Even if the child lives in another state where the age of majority is 18 for everything, your Colorado document is going to control what's the age of majority. So if it's someone under the age of 21, you need to have some sort of a trust provision. You can have it stay in trust longer. If you have children that are close to that age or even that age now, I used to think, by the time they're 21, I have children over the age of 21, and I'm not sure I would want them to have all the assets at age 21. So you can keep it in there longer, because I'll come back to the protection point here in a moment, but also if there's someone that perhaps has, maybe doesn't make good choices with relationships, and so you need to protect that person from exposing their assets to a soon-to-be divorce. There's a way to do that. Sometimes if people have a history of addiction or alcohol abuse, those kind of things, a trust can be a really, really valuable tool to still allow that person to have the benefit of what you've worked hard for, but you're protecting them from themselves. I mentioned the protection thing a moment ago. Sometimes I will have people say they want a trust so that they have what essentially would be liability protection. I want to use this trust and put my assets in here so if I'm sued, no one can get them. You can't do that for yourself because you're holding on to it. It's an extension of you. Public policy says if you created this trust and you can change it however you want, you still have control over it, just like it's your own asset. But once you've put assets in there and it becomes irrevocable, whoever's benefiting from those assets in there, as long as they're still in a trust, they have that protection. That's referred to as spendthrift protection. And don't worry, there's not a test, but just in case you've heard these terms, hopefully they make some sense. Because you've created the trust for someone else, and you can have provisions there that essentially say, well, anything's in this trust, the trustee is the legal owner. The beneficiary is the beneficial owner. And I don't want you thinking, oh my gosh, I don't want to trust because the trustee owns it. No, the trustee cannot have any selfish interest. That's criminal if they do, okay? But it means, like back to the house, if we look at the clerk and recorder's records, it shows the trust is the legal owner. It doesn't tell us who benefits from that house. It just tells us who legally is responsible for it. So if the trustee owns these assets, whomever is your named beneficiary, that's the one that has the beneficial owner. But a little bit ago, I said all the beneficiary does is stand outside the trust like this. That's because the beneficiary is waiting for the trustee to take the asset and put it into their hands. So as long as it's not outside of the trust, or the flip, as long as it's in the trust, it can have significant protection. There's ways to do trustee discretion, but just know that that's a possibility. So that oftentimes is why people will use trust too, especially for people that aren't kids. Yes?
I want to bounce back. There wasn't a break from me.
Oh, that's fine. I'm sorry.
It's going to be complex. Let's say you have a trust, and for whatever reason, I create a trust here in Colorado. The trustee is in Texas. I then move to Maine and make an amendment. And then what state is the bill under? What state is the...
I understand your question. So depending on where you, the settler, are that created the trust, the assets may be somewhere else and the trustee may be somewhere else. What law controls is kind of what you're getting at, correct?
I'm going one step further, and that's the documents are created under the auspices of one state, and then I amend it in a different state.
Yeah. Most documents, so not the trust, but all your other estate planning documents, back up, all estate planning documents are controlled by state law. There are some differences, but I don't know if this is exactly right, but I would say roughly 95% of the relevant laws are very similar in each state. Not a trust, but the power of attorney documents in wills. If you created documents in Colorado and you moved to Maine, you really should consult Maine counsel because your power of attorney documents in your will should probably be changed. The trust is really up to you. If you lived in Colorado when you created a Colorado trust, or even if you didn't live in Colorado, but you had Colorado real estate and you created a Colorado trust, as long as one of those two things happened when that trust was created, you can move wherever you want. You can get rid of the Colorado property, have property wherever you want, and you legally do not have to change. Really what you're getting at is the choice of law, because that document will indicate that it's Colorado law controls, is a simple way to put it. If there is a reason to change, like say you moved to Maine, you had a Colorado trust, you probably would want to say, should this be under Colorado law or Maine law? You know, so you're law shopping, what's gonna be the best. And really the only time that becomes an issue is, again, believe it or not, sometimes people fight about things that are in the trust, or how is this to be controlled. That's when the choice of law is going to make a difference. So I know you're looking for an exact, clear answer. There really isn't. It's going to depend on the facts and circumstances. But if you have a Colorado law or a Colorado trust and you move to Maine, it's still enforceable. And you pass away and it's under Colorado law, it's fine. When you pass and a trust, or at any point a trust becomes irrevocable, typically it needs, some states it's mandatory, some it's permissive but not mandatory. You need to register it with the court, and then at that point you're going to get into, again, which law controls. My simple answer is, if you move or you start changing property, probably consult someone at that time. Your trustee, though, can be anywhere. So you could have a Colorado, and I have clients who have that situation. They might have a Colorado trust, but they're trustees in Texas or Nevada. Do you have
This is actually a concrete question, but let's say the trust is revised because heirs changed.
Uh-huh.
And it's revised. Does the fact that a Maine lawyer changed it, does that?
If it's still going to be, if it's a Colorado trust and it says Colorado law controls, that Maine lawyer should be licensed to practice in Colorado. But having said that, as long as if it was amended, so you're just amending who benefit, the ages of how somebody benefits, it wasn't too crazy, they may have lucked out and it's perfectly fine and enforceable. I mean, they could get their hands slapped because they were practicing Colorado law. But if they took that, if they changed it so that, which I don't think is the case, and said it's now governed by Maine law, they probably are absolutely correct. Rest assured, you're not the only one that this has happened to. Okay.
But
Yeah.
specifically, the takeaway from this is, if you create a trust in a state, slap your own hands before you start trying to amend it in another state.
Yeah. Yes, and I would probably go back, especially if that initial attorney was still practicing, I would probably go back and ask that attorney the question. Yeah. Okay. Yes?
So, when you have a revocable trust and you pass, then your will is, which in my parents' case was part of a document also created alongside the trust, the pour-over will, that had to be filed in the state where mom died, which was next door to the state where everything was created, but it was
I know what you're,
actually had to be filed with the county
yep.
in which she died, so that creditors could easily find any outstanding bills.
Yes. Nothing is simple, is it?
No, but I mean, that in my most recent experience was a governing factor in where things get filed and why you might want to have documents updated to your state of last residence.
Yes. What you're getting at is everything everything I've presented for the most part has been more of the planning, but you're absolutely correct. It could be that, and kind of to the last question's point, that if you do move, have those documents looked at. But if a person is, wherever a person resides or actually is domiciled, there's a difference there. Domiciled means that you're not only living there, but you intend to live there. So it's not like you went on vacation, okay? So you're domiciled there. That is where, if a probate needs to be open, and you're right, they're referred to pour-over wills, because that will just says whatever I might have that's probate at my death pours over to my trust. So it could be that you had all your estate planning documents drafted in Boulder County, Colorado, but you ended up passing in, I don't know, somewhere in Nevada. And wherever you pass, that county is where that will be probated. And yes, that will has to be sent into that county court, and it depends if it's county or district. Again, it's the state rules. And what would have happened then is those, whatever assets were probated, then poured over, so they were titled after death in the name of the trust. And if it's a Colorado trust, then the Colorado trust controls. And interestingly, the trustee could have registered that trust in Colorado, even though the probate happened, in my example, in Nevada. Yeah, and yes, that's another thing. If you have to open a probate, you do so in a timely manner. I mean, if you wait years, you don't, but the normal way, you have to publish notice to creditors. If you've ever noticed in the newspaper, and if you're really paying attention, it'll run for 3 weeks, okay? And then there's a deadline for creditors to file their claim. If you just have a trust, there's none of that. So you don't have to publish notice. Not that anybody's hiding from creditors, but there again, well, some people do, I suppose. But it's an added expense, and the probate thing takes time. It's, especially in the 24/7, we want an app for that environment that we live in. You have that, it's for 3 weeks, and then they have, 3 to 4 months, depending on where you live, to file claims. So I tell my clients, you're not making a distribution until we pass claim deadline, because as angry as people may get that they're not getting their stuff that they know they get under the will, they get more angry when you say, we need to pay a creditor, give me some back. So yeah, it takes a while.
So in the state of Colorado, if you have a trust, you do not have to file?
If you're not opening a probate, the only reason you publish notice to creditors is if you've opened a probate. If it is entirely non-probate, so you have a trust or you just have designated beneficiaries, you do not publish notice.
Since we're well down this rabbit hole, so I'm going through Maryland law at the moment, and there's a provision in Maryland law that says that probate assets, the estate pays all creditors. The will and the trust say that the trust pays all creditors. What happens?
That does get interesting, and I'm not familiar with Maryland law specifically, but when drafting wills and trusts, we want to make sure that those reconcile. And sometimes a trust will say the trustee may, help basically contribute to the probate estate. Sometimes it says it shall, sometimes not at all. If the law says the estate, and I'm just guessing this, but if the estate documents allow the will and the trust, so the personal representative and the trustee to play nicely together and share those assets, then it could come from either. If for whatever reason it all points that it needs to be the estate, then that's it. And anticipating your next question, what if there aren't enough assets there? That's what great case law is made of. And that's where it gets challenged. Yeah. Especially if people don't get along. What else I thought you were going to say is if there are claims, but there aren't enough probate assets, but we know that there was life insurance or there were other non-probate assets that come in. If it's an unsecured creditor, just a credit card company or something, you probably aren't going to be too fortunate. If it's somebody like Medicaid that sends out the Medicaid recovery questionnaire and finds out that there were a whole lot of non-probate assets, I saw this with a family I worked with not very long ago. They reached in and grabbed life insurance proceeds from people because there weren't enough assets to repay for the cost of the Medicare care. So there is no clear answer. You will have, if everyone gets along and just says, oh yeah, let's just pay, then it works out.
One step further down the rabbit hole.
Mm-hmm.
If the probate assets are non-liquid and there is liquid trust assets. So for instance, if the money is in an IRA,
Uh-huh.
if the probate, somebody forgot to put down a
Right.
beneficiary or whatever.
Yeah, and it just goes to the estate.
So it goes to the estate. The estate can't really touch it, kind of, without penalties. So can you take a distribution or a dead man?
Yeah, the question is if the probate asset is perhaps a qualified asset, meaning like an IRA, something that has a required minimum distribution, can that, and that's the only kind of liquid asset, can that be forced to be distributed? Absolutely, it can. Oftentimes what happens in those situations, if there's, say, land, and then there's more liquid, even if it's an IRA, ideally, especially if I'm working with clients that we're trying to figure this out, I mean, very simply, play nicely and just work this out, because otherwise this is going to go to court, and I've seen this happen, and the judge is going to figure it out, and the judge really doesn't care what any of you think. So this is where you hear of people, we had to sell the farm. Well, you didn't necessarily have to sell the farm, but you didn't come up with other assets. And that's a part of good planning, that if someone knows there's going to be some bills to be paid, whatever they are, or you want assets to go to this list of 7 people, and you've got a bunch of land, and then you've got a few liquid assets, and it just, I mean, you don't have to do calculus. It's simple math that's not going to work out. Then perhaps the only choice you have is that you're going to have a judge figure it out, just going through, here's the priority, and we're going to sell the land, and if somebody wants to buy it, you can buy it. Otherwise, we're selling it so we can pay off the beneficiaries or creditors. Yeah. Yes.
Question.
Sure.
If you have a company, an LLC, real assets
In the LLC.
in the LLC, would you
Good,
trust?
good question. And when I said that I do a fair amount of work with closely held business families, that is precisely the point I'm making. And I should preface this with, I probably don't have a whole lot of, or there's not a lot of full-time litigators out there that like what I do, because what I'm trying to do is make sure that whom you intend to benefit from your estate does, and it's not a bunch of lawyers. Because you are the member of the LLC. The LLC owns those assets. You have a personal property interest in the LLC. It's like you own shares of the stock. So you just talked about the assets of the LLC. You don't own those. It's the LLC. So you want to make sure that your LLC, your operating agreement, and your will and trust reconcile. So if you want to make sure that these three people benefit from the LLC assets, actually what you're saying is you want those three people to become members of the LLC. And it needs to be worded that way, and we could spend a day talking about this, but one thing to think about is that your operating agreement should address, very broadly, I refer to it as transfer of interest provisions. You know, you could think buy, sell, but it's beyond that, because maybe you want it to, you're in a situation with an LLC that you want to leave your interest perhaps to your spouse. You're leaving everything to your spouse. Well, if the LLC, I've had this happen, the LLC maybe is made up of three brothers, and they all like each other's wives as their sister-in-laws, but the last thing they want is for them to be their business partners. But each of them has said, well, yeah, I want everything to go to my spouse. Well, are you okay if that LLC interest goes? No, Like, well, you know, again, you're gonna have the court decide, and usually the business document wins out. So, not to spend a whole lot of time on this, but that's where you've got to realize that if you don't want someone to have perhaps the LLC interest, but maybe you want them to have value of it. Or say, for example, you have three kids and you want two of them to actually participate in the business, but you don't want one of them to. Well, then we either equalize it with other assets, or we give them away that they're all members of the LLC, but then you have provisions in there how they can buy each other out. So you're not having to come up with extra cash, but you also make sure that they're not gonna force a sale of the assets. So, yeah. It's very doable, but you brought up a really good point that I get asked all the time. They're not your assets. Those assets are controlled by the LLC documents. So, did I see another hand? Yes?
Is there a time limit after my parents pass and for the trust to distribute the assets to the beneficiaries?
You're going to love this phrase, especially if you're the trustee. You need to do so in a reasonable time, or you will be in breach of your duty. So, if there's a bunch of houses and land and that, it's going to be longer than if there were two bank accounts. But then again, there's an administrative side of it, so that's why the term is reasonable. Clearly, if you have hit a year, you've got a problem, unless you've talked to all. Yeah, I mean, at least to have a plan. I typically say you better be communicating within a couple of months. Once somebody approaches me that, like in your position, that this trust needs to be distributed, it's having open communication is worth a lot, that we know this is going on, we'll be in touch in a month, whatever, you let people know. Perhaps they're all very good reasons, but as soon as you don't communicate, you'll start to see people file all kinds of actions and then people get upset. But it really depends on the facts and circumstances, and it may be that you have to do some tax returns. But I would say within a month or so after, ideally within a month, 2 months tops, that you should have at least some communication with the other beneficiaries.
As trustee, the assets were distributed when they were left with the bank accounts. And
Yeah.
when it tied up for several years now based on.
Yeah, and that makes perfect sense, but you at least communicated, and that's, you know, if they're liquid assets, if it's that you're trying to get the best and highest price, and there's some reason, maybe it was under a lease and you're waiting for that, yeah, that makes sense. So, yeah, you're fine. Yes?
More down the rabbit hole here. This rabbit hole. Distribution of assets. So let's say you have money in a trust, bank accounts, multiple bank accounts. Fundamentally, this question is trustee versus beneficiary, successor trustee versus beneficiary. For everybody else here, trying to get a bank to change a trustee is, oh my heavens, more difficult than.
Yeah, depending on the bank, yes, and I won't.
So is there a better way to do that?
When you say successor trustee, do you mean after the person passed? That really shouldn't be that difficult, although honestly, there's 1 or 2 banks I can think of that, yes, it probably would be. There's forms you can use. I mean, I typically make sure that we have a trustee acceptance form that the person signs. You present that, the EIN. There's ways to do it, and sometimes it's that the bank just thinks they're making up their own rules, and you just have to call their bluff on it.
I'm currently dealing with about 20 banks,
Huh,
and every single one of them has their own process,
yeah,
and every single one of them thinks they're in charge, and every single one of them wants me to go find a branch of their bank from some other state
yeah.
that, you know, might be in Inglewood or
Yeah.
Cheyenne.
That's,
whatever.
sometimes that requires, it shouldn't, but it may just require a letter or a discussion from someone within a law firm to remind them. And there have been, I can think, a time or two where we've gone and gotten a court order. Only once have I had a bank tell me they're not going to follow a court order, which gets a little interesting, but yeah, it's no simple answer, but
I was wondering if it was easier to make it so that the successors are beneficiaries and
no, that
somebody
doesn't.
else is named as a trustee that's, or something along those lines.
No, actually, I would think there would be, if they're gonna give you a problem, excuse me, that there would be more hesitation if you were trying to push the issue and you were a beneficiary and a trustee. Because they might think you're self-serving, even if you're not. So, I'd be happy to talk with you later about that, but yeah. We are about, I think, where we should wrap this up so that we don't have deer in the headlight look, and I don't want you to forget everything you might have picked up. As I said, a trust is one type of tool or one additional resource that you could have in an estate plan. There's a variety of uses for them. I've touched on a few. Chances are you're probably leaving with more questions than you even thought you had when you came, which means I kind of did my job, that it made you start to think about things. You have my information. If you do have a question, feel free to give me a call or shoot me an email, and I'd be happy to talk with you. And Barb, I thank you. Is there anything else? Okay.